Thanks for joining this episode of the number 86 lecture series, in which Professor Richard Epstein discusses torts in the Roman law. Topics in episode 3 include liability and risk, deliberate harm and negligence, self-defense. This lecture is part of a series with Professor Epstein on how this ancient legal system can provide crucial insights about modern problems. Professor Epstein is one of the most prominent legal scholars of our day. He is the inaugural Laurence A. Tisch Professor of Law at NYU School of Law, a senior fellow at the Hoover Institution, and Professor of Law Emeritus and a senior lecturer at the University of Chicago. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
In the previous episode, you discussed causation in the Roman tort system. What's the next logical part to consider?
Now, the second question, in addition to causation within the Roman framework, has to do with what we tend to call, what's the basis of liability? The stock example that can be given of this is I'm sitting there in a woods and I'm taking aim at a target. I believe that there's nobody around. There's a public road behind me. Somebody's walking on that road out of my view. I missed the target and I hit the stranger. Am I responsible, notwithstanding the fact that I had no intention to harm? And in fact, just for the sake of argument, given the low probability that somebody was around, there was no duty for me to check out the premises. He was not a trespasser against my property. It was just a very low probability event. And if you look at the way in which the Roman text is organized, it says whoever harms another individual is, in fact, going to be responsible. And all it seems to do is to require an intention to do some act, but not an intention to cause the particular harm that was brought about. And so essentially what happens is you now get yourself into a system of strict liability. You do an action, it results in harm to strangers, then prima facie, you're going to be responsible for it. Now, there's some people who say, no, we don't believe that. And if you look at the Roman text, there's this kind of subtle evolution that starts to take place, which interestingly enough is identical to the evolution that took place about 1,800 years later, 1,700 years later in the English system, which is somebody says, we really think that it's kind of hard to hold somebody responsible when they had no idea what was going on. And so we're going to basically say, you may well be strictly liable for all this stuff, but we're going to give you an affirmative defense, which says, but I took reasonable care under these circumstances to avoid the harm, and therefore I ought not to be liable, even if it turned out that I wasn't there. And so you then get the question as to whether in order to get liability, the strict model works, the negligence model works, or the deliberate harm models works. And you've got all three of these concepts sloshing around at the same time. And the question is how it is that you manage to put them into some sort of order. And this is the great challenge that exists under Roman law, and it also turns out to be the great challenge that exists under Anglo-American law.
So how do you approach this problem when it's such a big challenge?
Well, I think if you want to do this, start again with a pleading device, which says we're only working about a prima facie case, which means this is going to be sufficient to create liability unless you give us some good reason why it is that the liability ought not to exist. And one of the things that Gaius does in Book 4 when he starts to talk about civil procedure is he talks about the rules of pleading that arise in these various cases. Now, what are these rules of pleading? Well, in the Anglo-American system there, prima facie case, affirmative defense, full stop. But if you go back to the Roman system or to the early English system, that's not the way in which it worked. It was really very, very different. And here's what the basic situation was. You make this allegation, you hit me. Now, in and of itself, that doesn't say anything particularly bad, because I could hit you in a way which actually revives you when you're in some kind of a swoon, and nobody's going to be held liable in tort for helping somebody. So essentially, at the end of the causation statement of the use of force is an implicit assumption that it brings about by physical or chemical changes a state of affairs that is worse to the victim than the one that existed. So we tend not to think of causation as a universal false problem involving any physical change, positive and negative in value. We tend to isolate for the purposes of the tort tort law, the negative things, and we talk about causation and harm as though the two things are necessarily linked together, when in fact, conceptually, they can be kept quite distinct. Well, so we got this prima facie case that comes out, and you hit me and you change these things. And essentially, the basic argument that one makes is I, the defendant, have taken an action in the state of the world which benefits myself. And if you look around, it turns out that that particular action has harmed somebody else. Do you want to create a system, presumptively, in which I can internalize all the benefits of my own action, but I don't internalize the cost of that particular action? And the answer is like, why? And then somebody says, well, suppose it turns out that the probability of harm is very low. Is that a reason why it is that you shift to the other guy? Perhaps it ought to stay with me. And if it's very low, and I know I'm responsible for it, I'm much more likely to take fewer precautions than it turns out if I know that it's high. And so what happens is the probability of harm is a rough signal to somebody. If you're in heavy traffic, you drive more carefully. If you're on an open road, you can open up the throttle. If you're dealing with firearms in the city, you better take care. If you're dealing in the country, maybe less so. But the argument is it alters your care levels, but it doesn't alter your obligation, whether a long shot comes through or something else comes through. And so the strict liability principle starts to exist across these cases. So then what is the defense? And what we've said is we don't care about the absence or the want of care in these cases or the existence of care. And what we care about is what it is that the plaintiff has turned out to do. And we start to look at this. And so to give the famous kinds of case which comes up in all these legal systems, suppose it turns out that there are some dogs and I have a stick and I'm trying to separate these dogs one from another. And what happens is I bash this and bash that. And one of the dogs I own and one of the dogs is owned by somebody else. And this guy comes up behind me and he keeps coming closer and closer to the situation, knowing full well that I'm thrashing the stick around, trying to do something for his benefit. And when I pick the stick back, I poke his eye out. And the question is, should I be strictly liable for that? And well, if this were a person who was minding his own business, didn't see what was going on and was on his way, why not? You're trying to save yourself and your dog. But in this particular case, this is somebody who essentially, by approaching closer, assumed the risk of the particular harm in question because he hoped to be able to see. And so what happens is the strict prima facie case essentially now yields to what we call an assumption of risk defense, meaning you have assumed the risk of the accidental harm that has been caused, and so therefore no liability is responsible. And it's extremely difficult to find anybody who will categorically reject an assumption of risk defense, although people want to make it very clear that you know the difference between assumption of risk and knowledge of risk.
Can you talk a bit more about assumption of risk and knowledge of risk?
So if we take a different situation, I'm walking down a public street, and I know that there are a bunch of brigands around there and people are shooting guns, and we know that they're acting unlawfully. Have I assumed the risk when I go out and with knowledge of this stuff and get injured? And, it's much more difficult to say that because then what you're saying is these guys can act like mayhem and I'm forced to stay home. I can't do anything to avoid this harm. And so we draw the distinction between volenti and scienti, between knowing and accidental stuff. This becomes much more clear in the Anglo-American law in the 19th century, but it's clearly implicit in the Roman stuff that is dealing with the same problem. And so you basically want to figure out why this guy is hoping to get some benefit from the activity that you're doing, getting a closer look because he's trying to save your dog, than you would in this other case. And so assumption of risk of an accidental harm is perfectly good. Now, if you go back to the particular pleading rules that we started to talk about under these circumstances, what happens is the ancient rules did not stop at a defense. So they said the prima facie case is defeasible by showing an affirmative defense. And now the affirmative defense could be defeasible by showing something that comes up with it and takes over the situation. Well, what might that be? Well, now here's what you do is just change the facts a little bit. And you say, suppose when this guy was wielding the stick, he may have been a little bit careless. Perhaps he should have looked around one way or another to do that. Would the negligence be sufficient to overcome what's going on? And there's going to be a lot of debate over that, but most people will end up saying, look, this guy is in a pretty frantic situation. The other guy has a clear view and full knowledge of what's going on. And you're telling me that the fellow ought to be responsible because he has imperfect knowledge, knowing full well that if he turns around, he may make it less effective for doing the things that he wants to do. So all things considered, no, we think that this kind of negligence is not going to be sufficient to override it. Is this a universal judgment? Absolutely not. So to take another situation, suppose instead of trying to separate two dogs, somebody hires you to perform an operation, and it turns out the question is, when he cuts and creates a surgical wound, have you assumed the risk of that particular room? And the answer is, if you haven't assumed the risk of that room, it means that every surgery which is going to involve an initial cut, is going to also involve the lawsuit. And you really want to have to pay not only for the surgery, but to pay him money so he could pay you money for the harm that he inflicts. And everybody says, that's kind of crazy. So there has never been a case of medical malpractice. We use the word mal for the purpose, which allows you to recover for the inevitable and accidental harms that take place, or even the deliberate harm in this particular case. That's what you have to do. But suppose it turns out now you assume the risk of that, and you have a surgeon, and the surgeon knows what the protocol is with respect to treating certain kinds of operations. And what he does is he fails to follow the customary standards. Now, this is no longer this random man trying to separate two dogs. This is a full-time professional that's going on. And so you could make the perfectly respectable argument that under those circumstances, if he does not observe the standards of care in his own profession and causes a harm which would never have occurred if he had observed the right standard of care, we're going to force the liability back upon him. And so this is the origin of medical malpractice. Well, how good is that judgment? It's a very tricky judgment, it turns out. Because what you do now is you say, I'm going to hold you responsible for negligence. And these harms are going to be very big numbers. You're now going to have to pay this guy a premium which is sufficient to cover the potential liability for negligence. And that's obviously smaller than covering the cost of the surgical wound, but it's not a trivial number. And people say, it's just too much for me to have to pay you to cover myself, so let's make a deal. And so what happens is the malpractice case, you can start having contract rules. You can say, in effect, that there's a cap on damages. You could say that it has to be a very large breach of duty, and not one that happens or could not happen in a particular case. You can do all sorts of things. And this then says what happens is we're now dealing with the problem of concurrence of action. Whenever you have a harm that arises out of a consensual situation, do you allow people to control the risk by contract, or do you force the high tort standards of total loss upon them? And in many cases, whether or not the doctor did or did not do the right thing becomes really hard because you anticipate certain situations and come up with other situations, and then you have to make adjustments. Did you make the adjustment quickly enough or not? Do you really want to second guess things in that particular fashion? A better doctor might have been able to do this and you did not. Most people say no. So essentially what happens is you can see we now contextualize things, and the malpractice case may well give you rise to very different solutions from the situation with the dog and the stick.
What about a situation where someone knowingly inflicts harm?
Well, in that particular case, now we just change it one step further. And what we do is we assume that the guy knows he's behind him, the other fellow, knows that we don't like this particular fellow, and he says, I've got the perfect chance for revenge. And then with full knowledge that he's standing there, he swipes the stick extra hard and takes out his eye. And so we now have the following very powerful judgment, which is pretty uniform everywhere, which is if you engage in the deliberate infliction of harm, you will be responsible even if the fellow undertook and accepted the risk of an accidental harm. And this is a principle which applies as much in Roman law as everywhere else. And so if you start looking at that term culpa, which we talked about a long time ago, what they're saying in effect is you become blameworthy in these situations when you engage in deliberate wrong just as you become blameworthy if you're disciplining a child and you engage in reckless behavior on the one hand or wanton destruction on the other. It has nothing to do with negligence in this particular case. It takes more than negligence to overcome the assumption of risk defense by considered judgment. So there isn't a uniform theory of liability which culpability equals negligence. In fact, negligence in stranger cases is too stringent a standard, because the fact that you are very careful should not excuse you from harming a stranger. And then in these consensual cases, it may be too rigorous a standard. You should be protected except to the point where there's recklessness or willful disregard. So now what happens is we've introduced the world of intentional harm, and we can see how it carries over to other cases. Think about road accidents. It turns out that, these involve behavior by both parties. And if it turns out that I'm speeding and injure somebody, I'm going to be responsible for not dealing with the rules of the road. And if it turns out that somebody blocks the way, generally he's going to be responsible for the harm that I suffer if I can't stop in time, and won't be able to recover for the harm that he suffers if I hit him. But suppose it turns out I see somebody in the road and I say, Jesus, he's there, and I decide to speed up and deliberately injure him. At that particular point, nobody has any sympathy whatsoever for the fellow who deliberately causes harm to somebody else. So you flip the thing over again. Prima facie cases, you hit me. Affirmative defenses, you didn't follow the rules of the road. Explication, or rather replication or reply, is you did this wrong. And this follows very closely the Roman system of pleading.
Is self-defense treated differently than deliberate or accidental harm?
Well, now we also have another question, which is, suppose, in fact, when I struck that strict deliberately to hit you from behind, I understood full well that you weren't coming just to look at those dogs. You were coming to gang tackle me because you basically wanted to hurt me. So now what we're doing is we're talking about a system in which the relevant concept that we have to deal with is the system of self-defense or defense of property. And one of the things that we can say is, you know what? We don't like this defense. We're not going to give it. And the Romans, when they looked at it, said, no, self-defense is something which you're entitled to do as a matter of natural reason. And if you spell out the utilitarian consequences, you can see why it is that their judgment on this is one that is accepted everywhere by everybody at every time. There is no legal system which simply rules self-defense out of order as a justification. And why do we use the word justification? Because now this is a deliberate harm that we're inflicting on somebody, and we're saying if we had to do it over again, we do it exactly the same thing. If it were an excuse, I'm sorry I slipped and I hurt him, and it happened a second time, would you say, gee, I slipped the first time, I'm going to make sure I slipped the second time? No. What you're not going to do is do this. So you want to have strong justification for essentially taking after somebody else. And the alternative is, if you cannot protect yourself, then this fellow is going to be able to maim and to kill you. You will now have a cause against action against him for a deliberate harm. But if you're dead or seriously wounded, it's not going to do you much good. If he turns to be insolvent or leave the country, it's not going to do you much good. So essentially what we say is, if somebody uses force against you, you may use force to repel him, which is exactly the phrase that the Romans used to deal with this particular situation. And they did so correctly under the circumstances.
Are there limits to what can be considered as self-defense?
Well, then there's the next particular question is, once something is done in self-defense, is that the end of the matter? Or, in fact, is there some limitations on the use of self-defense? And the answer to that question, again, has to be perfectly clear. You cannot use self-defense as an opportunity to slaughter the innocent. And so what happens is you start thinking about other ways to look at this. And one of the concerns that you raise is that, is the force that you're using excessive relative to the need at hand? And so if somebody's attacking you and he's old and he's feeble, and you could simply take the staff out of his arm before he gives you harm, and you say, sorry, I'm not going to do that. And what you do is you just take a maximum blow and darn near kill the fellow. That's excessive relative to the risk in question. And by and large, the use of force is a privilege that we give to you, but it's narrowly construed because we don't want the force to constantly expand over and over again. And so the rule is, if the force turns out to be excessive, then in effect the principle of self-defense will be abrogated to the extent that the form is excessive, but not otherwise. Well, it turns out, does this end the story? And, well, maybe you can excuse the exercise of excessive force. And the answer is, it turns out that you can. Suppose somebody comes after you, you're slightly dazed. If you understood the full situation, had full capacities, you would have realized that you could have just simply put the stick to one side. But given your tottery state, you kind of overreact one way or another. And the question is, when you make a mistake because of the danger of your condition, does he have to, quote unquote, take his victim as he finds him? And generally speaking, the answer is, you can overcome the stuff associated with excessive force by showing that you acted, given your knowledge, in good faith, so you can excuse the excess of force, not justify it, and therefore get yourself out of responsibility. So what we've done is we've taken this argument and we've now moved 6 stages. But, you could keep moving it further if there are other things you want to introduce. And one of the common distinctions that's made in the criminal law and the civil law is there are 2 kinds of people we have. One, there's the ordinary Joe who doesn't quite know what's going on, and the other is the policeman or the trained official. And we can say of the former, well, he has no particular expertise. We can't expect very much of him. But if you're a policeman or an officer and you're changed in these things, you're not supposed to panic. You're supposed to understand what's going on. When you're on duty, you're not supposed to be half drunk. You're supposed to be completely sober. And so we can say, look, this excuse is denied to you by virtue of the fact that you've assumed the role of public authority, which requires you to act with a higher standard of care. So we now run this thing out to 7 stages. And it turns out, if you go through all of these steps, essentially what you will see is there's a place for strict liability with strangers. There are places with negligence when you're dealing with torts like medical malpractice in some cases. And then there are intentional harms when you start to deal with deliberate killings for which there can be justification. So all the pieces start to fit together if you learn how to do it. Now, it's interesting, when the Romans did this, they were very good in terms of their basic intuitions about the way in which the system was organized, but they never formalized it in that particular way. But what happens is you can formulate it in that way. And it turns out at this point, the use of language is completely natural. It conforms with the way in which everybody speaks and thinks about it. And you start from this single isolated incident in which the only fact you know is that one person hit another. And by the time you're done, you've got the civil code regulating officers as part of the same thing. And this is important, because we understand that police brutality is an issue that you really have to worry about and so forth. And if you can figure out why it is that officers are subject to special duties, it's going to change the way in this particular cycle is going to start to work. Now, I've just given self-defense as one illustration, but it turns out that there are others that you can start to introduce into this hierarchy, which are going to be extremely important. And one of them is consent to a deliberate harm, as in a fighting match of some sort or another. And here, of course, you always have the problem that you induce somebody into the ring by making them false promises of the compensation and that they would receive, or by telling them that they would be protected against serious injury because the other guy would be wearing padded gloves. And in fact, those gloves are loaded with iron bars inside of them so that the consent defense can be vitiated by fraud and so forth. It's the same cyclical arrangement that you have in these other cases. And then there's the very difficult question of cases of harm caused by necessity. And so what happens is you find yourself in a situation in which the only way you can protect yourself against the harm caused by X or by a natural storm is to take it out on the property of some stranger. The common case of this would be somebody's chasing after you, or a huge storm starts to arrive, and the only way you can escape it is to trespass upon somebody else's land in order to avoid the harm in question. And the issue then is whether or not this privilege is conditional or absolute. The case is sorely a more difficult case to understand, because now you're not trying to create defenses against people who are wrongdoers. The person whose property you're entered has done absolutely nothing wrong whatsoever. And so the question is, can you take his property or not? And what we start to do is ask the following hypothetical. Suppose it turns out that this fellow was there at the time of the necessity, and he comes up to you and he says, if you enter my land, you're going to cause me $5 worth of damage by trampling some of the gas. On the other hand, if you enter my land, you're going to basically be able to save your life, and that's going to be worth $1 million to you. So let's split the difference. Pay me $500,000, and I will let you answer. You're better off. I'm better off. A mutual exchange, gain, we let it happen. That argument has never been accepted in any legal system at any time because the holdout risk, when there are no alternatives, are simply too great. This is not a situation where you're going to a hotel, and if they raise the price to $500,000, you'll go down the street and get one for $50. And so the usual answer is, if somebody actually tries to keep you from coming on their land when you're faced with necessity, whether you're talking about the Roman times or the modern time, you can actually gang tackle him because you now have a limited right to the access of his property. And if he stands in your way, he turns out to be the wrongdoer and you turn out to be the innocent party. And so it therefore follows, if he's not around, generally speaking, you're going to be allowed to enter that land, take refuge there of one form or another, avert an enormous harm. But then the question is, what is going to happen under these circumstances if in order to save yourself, what you do is you damage some fraction of his property? And there's a sharp split of opinion, both in Roman law in this necessity case and in the Anglo-American law, as to what ought to be done. On the one hand, those people say, the only thing that really matters under these circumstances is that this guy get out safe. And if you're going to start worrying about whether you pay $50 or $100 worth of compensation, you're crazy. Make the privilege absolute. And there are other people who say, no, you're looking at this stuff. It's not impossible to ask somebody to say, well, we want you to save yourself, but we don't want you to absolutely take unnecessary risk with respect to somebody else's property. So what we're going to do is let you do what you want, but after the fact. If you damage property, you have to pay just compensation, so as to mean that the innocent party is put back in the same position after the loss that he had been before the loss. And so one of these things is a just compensation rule, and other is an absolute privilege. You then assume the government comes along and takes this stuff. Does it have to pay? And all of a sudden, these cases of necessity and conditional privilege start to tie in very nicely with the larger question of when the government takes your property under dire circumstances of necessity, does the usual rule of just compensation apply to it or does it not? For which there's a split of authority in modern times, just as there was in Roman law. So what happens is you can start to see the way in which all of these things start to work on the causation side. And that what happens is in virtually every one of these cases, to get things going, you not only have to worry about the conduct of the wrongdoer, you have to worry about the conduct of the innocent party, so-called. This is something which doesn't happen in the theft case. So it's a causal connection which is much more difficult to be able to do.
Who has the right to bring these cases?
We say it's always going to be the owner, right? And that's the obvious case. But we've already should be on to the difficulty associated with this particular problem. Because when we dealt with the Fortum cases, you had to ask the question, what happened when ownership was divided in one way or another? And sure enough, these things start to give you some genuine problems. And what are those particular problems? Well, who is this particular owner? And how does this particular owner start to work? If it turns out that somebody dies and then there's an heir, the heir was not the owner at the time of the injury, but does he get to recover as if he were? Or if it turns out that the thing is subject to a bailment, is it the owner who gets the damages for its destruction or the person who's in possession and so forth? And it becomes very tricky to figure out who's entitled to bring the cause of action. And the Roman system tended to want to fix on one of these parties. The modern system says each tends to recover for his own. Well, what do they recover? And this is the last point, the very last point, is the Roman system said the damage is equal to, at least in the case of the killing of a person, to the highest value that the slave or the animal had within the previous year. And this is a very strange formula. Why would one want to adopt it? Well, the ostensible justification given by the Romans is that we wanted to make sure that somebody was not hurt by the fluctuation in market value that took place over the previous year. And so we're going to always give the benefit to the innocent party by giving him this highest particular value. But the question then comes in, like, why? Suppose it turns out that the usual rule for the destruction of property is you give the fair market value at the time of death. That's the best estimate. Why do you want to go back and find some other number when it turns out that the consistent decline in the property is such that it's not likely to go back to that previous level? It's going to be a windfall. And so the correct rule is to figure out the time of death and not to give him an option to go back a year and pick the single highest time that happened. And every modern legal system essentially accepts that article. But it turns out that there's another element that's associated with this, which is what happens if a slave turns out to be injured in one form or another. So it turns out at the time of death, this slave is worth $100, but it was seriously injured in an action 6 months ago, before which it was worth $1,000. If you do the formula within the last year, then things are really going to be very, very strange, because it means that you can first recover for the injury from the person who inflicted it, and then you can get the higher value and harm at the time of death from the other person. And the Romans did not shrink from that implication. Plurimi, that is the highest, meant plurimi, and so they would give it. But again, when you start looking into modern systems, there's no theory of causation which wants to hold somebody responsible for something that he did not do. So these are the particular rules with respect to past harms that have never taken place. Now, in Book 3, and we'll finish on this point, of the Lex Aquilia, what happens is we talk about things that happen to somebody which doesn't result in a killing. So it's a burning of somebody or a rupturing of things. And the Romans basically said any kind of situation in which you create a bad physical outcome for somebody will be covered by this provision. And the standard illustration that they gave is somebody had a bunch of grain inside a barrel, and the owner didn't burn the grain. Rather, the thief did not burn the grain, or the wrongdoer did not burn. What he did is he emptied the barrel on the road so it was utterly useless. And, there's no destruction, but there's a destruction in use, and they say this would be covered. And in this particular case, what formula do you use? And here the Romans had a different verb. It was called a writ, which means that will happen. And so now it looks as though the standard is we're not going back in time. We're going forward in time, and we're saying, well, we'll give you the amount of money that it's worth as the matter turns out within 6 months. Is that a good or a bad test? One sense it's good, one sense it's bad. It's bad if it turns out that the loss was fixed. That is, the grain is lost, and that's it. And if it was worth $100 when it was lost, why do we want to make it $50 if it's lost later, or $200 if it's lost later? Stick with the value. But in some cases, for example, an animal is injured and it recovers. If you wait 6 months, you will now know that it's in the good state of the world, and so what you thought would be $1,000 in damage is only $400 in damage. On the other hand, you thought the animal might recover and it dies, and so $1,000 in damage now becomes $1,500 in damage. So waiting in this case is very different, because what it does is give you a more accurate estimation of what the actual damages are without creating this market fluctuation risk. So you have all of these elements coming together inside this Roman law stuff. And in the end, what really happened is this entire apparatus of justification and excuse, it all comes out of the single word inuria. Because what you're trying to do is to figure out whether something is unlawful. And the way in which you figure out whether it's unlawful is to ask the question about all of these defenses and exceptions and so forth. And it shows you what the power of exposition is. Take a single word in a document like this, and then you could spend an inordinate amount of time trying to explicate it. And if you get it right, you really understand what the system's about. And if you get it wrong, it could well be that you negate strict liability in all cases, which is what Gaius did. And so the Gaius treatment of this issue is much weaker than it is everywhere else.
Thank you for listening to this episode of the Number 86 lecture series. The spirit of debate of our founding fathers animates all of the Number 86 content, encouraging discussion and critical reflection relative to how each subject is widely understood and taught in law schools and among law students. Subscribe to the Number 86 lecture series on your favorite podcast platform to have each episode delivered the moment it's released. You can also go to fedsoc.org/number 86 for lectures and videos on federalism, separation of powers, the judiciary, and more. That's fedsoc.org/NO86. Thanks for listening. See you in class.